Okay. Well, thanks everybody for being here today. Those of you that are in the audience and those of you that are participating remotely. Hopefully this training will be of some value to you. We've, over the years and looking at and in talking to our different departments and the supervisors, I know that a lot of you deal with some of the topics that we're going to be talking about today on a regular basis or have become familiar with them over the years. But I also know a number probably don't understand all of the ramifications of liability and loss exposure. So I thought it might be a good idea to put something together for a presentation to supervisors and others of our employees who deal with these. And this will be another one of these presentations that will be recorded and put on the presentation and videos page of the county employee website. So anybody that is unable to listen today can get on there anytime and look at this. So without further ado, we'll get started on this. And there's quite a bit of ground I'm going to cover, so I'm going to run through this fairly fast. But still, for those of you in the audience, if you've got questions, be sure and raise your hand. I'll try to answer them, and then hopefully we'll get done in enough time for a little question and answer session at the end if there's still things that need to be covered. So, just a brief overview of loss exposure, and loss exposure and risk management covers a lot of ground. But there's essentially three main elements to loss exposure. And that's an asset that could be exposed to the loss, the cause of the loss, and the financial consequences of a loss. So an asset exposed to a loss can fall into four main categories. It could be either property, it can be investments, it could be cash, or it could be human resources. And of course, the one that we're most concerned with all the time is human resources. We don't want our employees to be injured in any way on the job, to be subject to any kind of loss exposure, not just physical, but also financial, and other things that could occur as well. So those are our number one priority is to protect our human resources. But then the others are also important as well. Obviously, we want to protect the county's investments in property and cash and other things, and do whatever we can to be sure that we're not paying out taxpayers' money when we don't need to. So the cause of a loss can fit into four main categories. That's the moral hazard, and that's a condition that increases the likelihood that a person will intentionally cause or aggravate a loss. And when we're talking about those, we're essentially talking about instances where we may have people who want to take advantage of our system and claim some type of physical injury or something else that caused them damage while they were at work, even though they know that this did not happen at work or it was not caused by anything that the county did. So essentially those are things that do come up. We do have employees in the past who've tried to take advantage of this, and sometimes it's hard to identify when they're trying to get by with something. So this is something that we have to keep in mind all the time and keep our eyes on. A morale hazard, that's a condition of carelessness or indifference that increases the frequency or severity of loss. And most generally, you think about there where you have some employees who are just not safety conscious. You may train them in safety, you may emphasize it repeatedly, but they just are careless or for whatever reason, they don't pay attention and have accidents and sometimes become repeat offenders and have multiple accidents. And it could come to the point where at some point in time, you may just have to get rid of that person because they are a hazard to themselves and hazard to the coworkers around them. Physical hazard, that's a tangible characteristic of property, persons, or operations that tends to increase the frequency or severity of loss. Obviously, some of our departments have a lot more physical hazards because they're out in the field doing a lot of stuff. So either as a part of their job because they're operating heavy equipment, or they're out in an environment where they're exposed to things that people in the office aren't going to be exposed to. Think about our public works department. They're out all the time dealing with things. sheriff's office, they have a lot of things they have to deal with that most other people don't have to. That increases their likelihood of something happening. And a legal hazard is a condition of the legal environment that increases loss frequency or severity. And when you think about that in overall 10,000-foot level terms, you think about how the litigation environment has increased and has been increasing probably over the last 50 years or so, if not longer, to where there's a lot more people suing for every little thing. And so that raises the cost of litigation overall across the country. In terms of what you have to pay for legal representation, but also in terms of what's awarded in the courts. And sometimes there's punitive awards in the courts that amounts to 20 or 40 or 50 million dollars. And all of that ends up adding to the cost of what we may have to deal with if we get involved in litigation. Types of loss exposures are personnel loss, which includes a loss to the organization of the value of a person, a financial loss to an individual or family, death, disability, retirement, voluntary separation, involuntary separation of that person. And of course, that's the biggest thing we're concerned about, is we don't want our employees to be injured or to die because of something that occurred on the job. And the last thing that we don't talk about a lot, but which is very important, is the supervisor or coworker civil action liability. Because if, as a coworker or supervisor, you do something or don't do something that causes a coworker injury, you could potentially be individually sued for that. I'll talk a little bit more about that here, but on personnel loss, if an employee is injured through the willful misconduct of the employer or a coworker, then the injured worker has the right to file a civil lawsuit against the employer and the coworker who injured the worker. And that's taken directly from the Industrial Commission of Arizona website. And a legal definition of willful misconduct is willful misconduct generally means a knowing violation of a reasonable and uniformly enforced rule or policy. It means intentionally doing that which should not be done or intentionally failing to do that which should be done, knowing that injury to a person will probably result, or recklessly disregarding the possibility that injury to a person may result. So a lot of our employees, I think, and particularly our supervisors who have a big responsibility for being sure their employees are safe, may not understand that. They may not understand that they may be held personally liable if something happens on their watch. And if they are doing so by violating a county policy or procedure, and something happens, then they may expect the county to defend them, but that's probably not going to happen because they violated a policy and procedure that was in place for the protection of employees. And so it may actually come back to them civilly, and aside from the fact that they're probably going to lose their job immediately for violating that procedure. So how do we control risk and reduce liability? Avoidance is one type, where we eliminate work activities that entail unacceptable risk, and we try to do that as much as possible. We do assessments on the different jobs that are going on out there and look at things that we may be doing that we shouldn't be doing. And then we also do prevention or reduction, which prevents losses or reduces the frequency or magnitude of losses resulting from the hazard. And that's where the jobs that we actually have to do that may be more hazardous than other jobs, we evaluate those, we do an assessment and determine, okay, just what are the risks here involved in this particular activity and what can we do to reduce those? And hopefully get those in place prior to anything happening so we can prevent or mitigate any type of injury. Transfer, and that essentially amounts to acquiring insurance to cover our losses from the hazard, ensure that contractors, vendors have insurance and indemnification that will cover the county when they are doing work for the county or they're doing something on county premises. Retention, that means to retain a certain level of acceptable risk in order to accomplish duties and required tasks. And so we have to do that in a lot of our jobs, and we also do that in the insurance realm. That's why we have a self-insured retention fund, And we participate in the Arizona County Insurance Pool, which is a self-insured retention fund where all 13 counties pool together. So that we have a certain amount of money that we put into that pool that's there to be used to defend for lawsuits and other type of losses. So when we're doing a risk assessment, we like to do risk assessments on an ongoing basis. Typically you do them initially when you've got a new building or you've got a new activity going on, but then you want to continue to reassess as you go along and as new things develop as part of that work activity. So typically you conduct a risk assessment of workplaces and identify the potential hazards. Usually this is conducted by the department or division in conjunction with risk management. And this assessment should cover, among other things, physical and structural hazards, such as high-risk work areas, human hazards, such as personnel needing training or working unsafely, or security concerns involving employees or visitors, environmental hazards, including hazardous chemicals, noise levels, HVAC issues, common workplace hazards, such as trips and falls, falling objects, electrical, incidents and accidents that could happen. And as most of you know, trips and falls are a big thing that happens a lot. They may not amount to much individually in terms of the cost of an individual incident, but they add up, and they're the majority of, usually tend to be the majority of the workers' comp claims that we see. Hazards specific to the particular job or workplace, such as operating powered equipment, heavy lifting, etc., and personal protective equipment needs, where sometimes people may not be using PPE where they should be using them. So we do the risk assessment, determine what needs to be done to mitigate those hazards, identify the corrective actions for each hazard, and set action deadlines for getting those corrective actions completed, and then complete and document the corrective actions. And documentation is very important on this to ensure that we're actually assessing the risk and we're actually taking action to remedy and mitigate that risk. Loss prevention responsibilities. Each department is responsible for its loss prevention. Responsibility ultimately rests with the department director, but each manager, supervisor, and employee is responsible for his or her job activities and workspaces and working safely with coworkers. Loss prevention's first priority is always employee safety, followed by preventing or reducing county legal liabilities and physical losses. Employee safety is addressed in a separate presentation, so we're not going to get into a lot of details on safety. A lot of the departments and out there, a lot of you have your own individual procedures for the specific types of jobs that you do. So we're not going to cover those in detail in this presentation, but we are going to address injury reporting, workers' compensation, discrimination and harassment, reasonable suspicion, and post-accident drug and alcohol testing. And some things have changed particularly on the post-accident drug and alcohol testing and some other things here that we're going to talk about that y'all should be aware of. And a lot of these things are covered in our personnel policies and procedures manual. So I know most people probably every day or two want to go to that website and read up on what's in those personnel policies and procedures manuals. So I may be just covering things you guys already know, but hopefully I'll bring up a few items here, and you can always go to those policies and procedures to look things up and to learn more about what I'm talking about. Liability can accrue to the county, and in some cases, individual supervisors or coworkers if these policies are not understood and followed. So employees' injuries. Contact risk immediately, and that means 24 hours a day, 7 days a week, for any on-the-job injury when an AED or CPR is employed or when an ambulance is called to a county facility. Risk should also be contacted immediately for injuries to the public on county premises or from county auto accidents. In some cases, you may not, well, in the cases of injuries to the public, you don't need to fill out an SRI, but you are going to have to do that for any county employees that are injured. So for life or limb-threatening injuries, you always call 911 first. Not a supervisor or not risk, call 911. If you're in any doubt at all whether that injury is serious, call 911. If injured or sick employees refuse ambulance transport, advise his or her that county employees cannot transport them to a medical facility on county time or with county vehicles. County employees can do so on their own time and in their own vehicles, but should be aware that they could potentially be at liability risk should something happen on the trip. And we have had this happen before where there have been employees who've had a medical event that was not an injury on the job, but some medical event from a pre-existing condition, and when the ambulance said and told their coworkers, "I don't want you to call 911." Well, it's your responsibility to call 911. If you perceive that that person is in distress, it's a potentially serious medical issue, you need to call 911, regardless of what that person says. And that is for that person's safety, number one. And number two, it's for protecting the county from liability if we don't call 911 when somebody's having a life-threatening situation occur. Sometimes we've had the ambulance show up and people have said that the person that's had the medical event has said, "I don't want to be transported." Well, EMTs will have that person usually sign a declination that they don't want to be transported, even though the EMTs or paramedics have recommended they be transported for their condition. And we have had cases in the past where after that's happened, that individual who had a medical event has said to an employee that, "Oh, can you take me to the hospital now?" Well, that's probably not a good idea. I mean, as we're saying right here, you can't take them in a county vehicle, you can't do it on county time, because we are assuming liability for that person at that time. So if you want to, you can volunteer to do it on your own, in your own vehicle, but you need to understand that you also are assuming some type of liability there. If that person should die on the way to the hospital, or if they have some kind of event that causes you to lose control of your vehicle and you have an accident, the best thing that could happen is that person rides in the ambulance. But if they don't want to, then what should happen is they should call a family member or friend or whoever and ask them to come and take them to the hospital. For non-threatening injuries, employees should call Triage Now immediately for a phone evaluation. This is not mandatory, at least it's not mandatory at this time, but we're getting some pretty good results from Triage Now. And we're seeing in some cases where people didn't call Triage Now and they went to the hospital or to a urgent care, they really didn't need to go. And we incurred a risk or a significant cost for them doing that. But it's not mandatory at this time. And an employee can instead choose to go to a medical facility. However, Triage Now evaluations have often eliminated the need to go to a medical facility, time off work, and the classification of the injury as OSHA recordable with its impact on county insurance rates. An employee can still decide to go to a medical facility even if they talk to Triage Now and the person on the line from Triage Now advises that it's not necessary, that you can still elect to go to an urgent care medical facility if you want to. So injury reporting. A supervisor's report of injury must be completed by the injured employee's supervisor and faxed to risk management at 928-718-4974 within 4 hours of the incident. And I see I do need to correct that, because now we're asking you not to fax it, but we're asking you to send it via email to our county risk management website. So we are asking you to do that, and we have that on the new forms that we've sent it out. So I do need to correct my slide here to reflect that. If the SRI cannot be completed in that time frame, risk should be immediately notified. And we understand in some cases it can't be done within 4 hours, and so we'll allow extra time for that. The reason we have the 4-hour duration put down here is because that in certain types of injuries, we have to get that information in right away as soon as possible, both to our workers' comp people with the Arizona County Insurance Pool, but also Sometimes it's an OSHA requirement in certain types of injuries that we have to do a notice within 24 hours, particularly if it's a very serious injury, and obviously in terms of a death, we have to make those notifications as soon as possible. So we have changed the SRI. A few months ago, we changed it to where we updated it a little bit. It can now be fillable online. We have that online on the county forms webpage. And it also has all the information on there that can be provided to the employee, and it has the email address that you can email us directly instead of using our fax. So the second page of the SRI list what the supervisor should be doing at that point and getting the SRI in and in follow-up actions, and it also lists what the employee should be doing as well. So what we prefer is when a person is injured, an employee is injured, and they get with their supervisor, the supervisor gives them a copy of that second page so they can look on there and follow the information on there. And it has the information on that they would provide to the medical facility, on the workers' comp contact at ACIP, the insurance pool. Has all the information they need on there to get that started, and has some additional things that they should be doing as they follow up with after initially being seen at the facility. So the SRI, the incident report forms, and current noticed employees showing selected urgent care sites are on the employee forms webpage. SRIs do not need to be completed for employment medical events that are not the result of a workplace accident, but risks should be immediately notified and may ask the department to prepare an incident narrative for the file. And that goes back to what I was mentioning earlier about employees that have a medical event on our premises. Even though it is not a workers' comp event, we still may want to document that by putting down a narrative of exactly what happened. Non-SRI employee medical events and injuries to the public should be documented on an incident report form, not an SRI. Note that the failure to provide a timely SRI can result in severe consequences to an employee's health and to the county's liability exposure and OSHA compliance. Workers' compensation. Workers' compensation cases are handled by the Arizona County Insurance Pool, except that Superior Court and probation employees are handled by the state because they're technically state employees. The county must adhere to all written directions from medical professionals regarding employees' return to duty, medical testing, and light duty assignments. ACIP may request a second medical opinion if it is felt necessary. Injured employees must follow medical professional treatment and return to work stipulations, or notify supervisors that they are not doing so. ACIP will provide direction to injured employees based on written medical recommendations. In some cases, ACIP will direct HR or the individual department to notify the employee in writing of certain light duty restrictions or requirements. All such documents must be reviewed by HR and risk prior to being sent to the employee. And under no circumstances can an employee return to work without a doctor's note that has been approved by risk and or HR. And we've had a number of cases where that's happened. What we found out is the employee was told something at the medical facility, but they didn't tell their supervisor what was told to them. In some cases, they just went right back to work, even though they needed to have a return to work note. And in some cases, we didn't find that out for a couple days later. And overall, all of you guys out there that work on this, that produce SRIs, do a great job overall. We don't have a major systemic problem with this happening, but it does happen. And so it's something that we have to keep our eye on and be sure that we take care of it. So definitely a person cannot return to duty unless they've been authorized to do so by a doctor's note. And sometimes what we found out is a doctor will send a note saying, this person can do light duty, but it doesn't give any details. And So we don't know exactly, well, what does that mean? Because light duty in different jobs means different things. And so in many cases, we've had to ask that employee to go contact the doctor and get another note that spells out exactly what they can and can't do. This happens pretty often. And that goes back to the medical professional that treated them, that the way they filled it out. So what's been suggested that we do, and I think we're going to implement that, is to provide a separate form when an SRI is filled out, and that separate form will actually detail on there what we're expecting the doctor to put on his note. Because it'll spell on there, here's the things that this employee could be doing. Could you say on your return to work note, or not your return to work note, but your light duty note, exactly what this person can or cannot do? So we'll actually provide them some information on that note to guide them a little bit. Maybe cut back on having to go back to them once or twice to get more details. So that's another improvement we're hoping to make. And individual departments cannot either verbally or in writing direct light duty or return to duty requirements that are in conflict with or additional to the directions from medical professionals and or ACIP. Supervisors will ensure that any employee with light duty restrictions strictly adheres to those restrictions. If the employee persists in violating restrictions, the employee will immediately be sent home. County employees cannot suggest to or pressure injured employees to return to full work status or imply that the injured employee's job may be in jeopardy as a result of the injury or the length of time required to return to full duty status. Employees must notify HR risk immediately if they receive a bill from a provider asking them to pay for services related to the workers' comp injury. And we've seen this happen fairly frequently, where for whatever reason, even though it was when the person went to the ER or whatever medical clinic they went to, they provided the workers' comp information to that facility. And you see what happens right away. One of the things that happens right away is a representative from ACIP will immediately contact our employee when they are notified that there's been an injury and start working with them on the day of the injury and actually also working with the medical facility they go to be sure that facility does have the address for which they need to send the bill on workers' comp injuries. But we've found time and time again that sometimes the bill doesn't go to ACIP like it's supposed to. It goes to the employee. And we've had instances where the employee has looked at the bill, has received one bill, maybe two bills, maybe more, and says, well, county's taking care of this, and they throw that bill in the trash. Well, then the next time they get notified, it's from somebody who's a bill collector who's wanting to collect the bill. And so what we have now on the second page of that SRI that I mentioned that we added on there that gives directions to the employees on what they should do after they're injured, we have at the bottom in big red letters that says, if you get a bill as part of the follow-up to your injury, if you get a bill from a provider asking you to pay, you must immediately notify risk or your supervisor, but notify somebody that you're getting a bill so we can get that straightened out and be sure that the bill isn't going to the worker, but it's going to ACIP for them to take care of. Controlled substances. An employee shall not report to work or while on duty shall not have an alcohol concentration of 0.02 or greater or any measurable presence of an illegal drug other than marijuana. Employee should notify a supervisor before reporting for work if the employee uses any controlled substances that state that this medication may cause dizziness, drowsiness, or adversely affect the employee's ability to safely operate a vehicle or equipment. So that's on the employee to make that notice. And our employees are usually pretty good about that, but we have, and usually on a fairly regular basis, we find out that sometimes that employee hasn't notified us. And that puts that employee and other employees at risk. An employee, unless certified for medical marijuana use, may not use, possess, or have marijuana in his or her system while on county premises during hours of work or while operating a county, state, or private vehicle on county business. Now, medical marijuana. An employee with a written certification of a debilitating medical condition diagnosed by a physician is a qualified patient eligible for the medical use of marijuana and may have marijuana in his or her system but may not use, possess, or be impaired by marijuana while on county premises during hours of work or while operating a county, state, or private vehicle on county business. Note that CBDs and essential oils may contain marijuana components even when labeled as being marijuana-free, and these will show on a blood test. I don't know where this happens much anymore, but for a while there was an issue with CBD oils. They were advertising them that they were marijuana-free, they were THC-free, but then they weren't. They were falsely advertising, and so the person that was taking those, and CBD oils can be very beneficial to some people, they thought they were doing fine until they got a blood test and then found out it showed they had THC in their system. So you need to be very careful about the type of those type of essential oils that you use. Be sure that you research them thoroughly and be sure that they haven't been found to actually contain those components that will show up in your blood test. Employees who are found in violation of the above rules will be subject to immediate termination. Okay, reasonable suspicion for federal motor carrier safety regulations. And so we've got a couple of different type of regulations here we have to go by. But the CDL drivers have to go strictly by what is required by the federal motor carrier safety regulations. So, FMCSR section 382.307 requires a CDL driver to submit to alcohol and/or drug testing if his or her motor carrier has reasonable suspicion to believe that the driver is misusing alcohol and/or using drugs. Only one supervisor is required to make the reasonable suspicion determination, but the supervisor must have had the required reasonable suspicion training, and we do offer that here at the county. If the supervisor is unsure about the behavior, Risk and HR recommend getting another trained supervisor to observe and render an opinion, if this is possible without delaying the process. That way you've got two different supervisors who are observing and looking to see if they can detect symptoms of impairment. It may be necessary to bring suspected employees individually into a private room for individual observation or to remove them from close proximity to other employees in order to better identify odors and behavioral warning signs. And we do have listed on the Personnel Policies and Procedures Manual, we have on there listed a number of common symptoms that you would expect if somebody was impaired that would apply toward a reasonable suspicion determination. So I don't have them listed here, but they are there where people can look those up. And those are what the things that would be used by supervisors who've been trained in reasonable suspicion to see if they can detect when they're observing somebody. The determination must be based on specific, clearly stated, and firsthand observations of the driver's appearance, behavior, speech, or odors by the supervisor. Indications of the chronic and withdrawal effects of drugs and alcohol can be considered. The supervisor must prepare and sign documentation of the driver's conduct within 24 hours of the observed behavior or before the results of the alcohol and/or drug test are released, whichever is earlier. Okay, the reasonable suspicion implementation procedures, and these are the ones that are in the Policies and Procedures Manual as opposed to the CDL guidelines. But section 5.42B4 covers reasonable suspicion protocols for implementing the FMR-SR regulations for CDL drivers and for other county employees, and key actions are summarized below. The observing supervisor's documentation of employees' behavior must be sent to the department head, who will decide if reasonable suspicion does exist, and if so, will authorize an alcohol and/or drug test. HR must be immediately notified at that time. The department head or designee will be responsible for arranging the employee's transport to the testing facility. The department head or designee who encounters an employee who refuses to take a drug or alcohol test must advise the employee that a refusal can result in disciplinary action up to and including dismissal. Supervisors cannot physically search employees who are suspected of drug possession, but must immediately notify law enforcement and the HR director. And risk will be involved in that notification as well. So for post-accident alcohol and controlled substance testing, and just a little prelude before I get into this, but for a number of years, if there was a vehicle accident involving a county employee, it was more or less automatic that they were taken for a drug and alcohol test afterwards. We sort of got away from that, I believe it was about 3 years ago, because OSHA came out with a ruling that said you couldn't do that because you were discriminating against those employees who came up clean. Personally, I still don't understand the logic behind that. And it may have been put in place because they were being pressured by, I don't know, unions or somebody else. But anyway, they come out with this saying, okay, you just can't say I'm going to test everybody that gets in an accident, because then that reflects badly on those who turn out not to be under the influence of anything. They got a lot of pushback on that. As a matter of fact, some businesses out there, and I don't know about government agencies, but I know a lot of businesses just decided to quit testing after accidents entirely because they're afraid of getting in trouble. And then OSHA had to send out it wasn't really a retraction, but it was a modification saying, oh, no, that's not what we meant. They said, what we meant, you just have to test people if you think they're impaired. Well, then you're back to reasonable suspicion. You know, you're just back to reasonable suspicion. However, OSHA did qualify it by saying that our ruling is trumped by any state laws that deal with this. So, what we started using, and I just recently received verification on this. At the time, I talked with legal about this, and I talked to them again here recently. And we follow what's in state statute. So ARS 23-493.04B2 allows for post-accident testing for the maintenance of safety for employees, customers, clients, or the public at large, and states employees may be required to undergo drug testing or alcohol impairment testing for accidents if the test is taken as soon as practicable after an accident, and the test is administered to employees who the employer reasonably believes may have contributed to the accident. Now, I will point out on this, it talks about accidents. That doesn't just mean vehicle accidents. That also means workplace accidents. So we have started just recently implementing a policy where we're going to be a lot more stringent on workplace accidents as well as vehicle accidents. And if we believe that the employee may have reasonably contributed to that accident, then they're going to be sent for testing. And I will say that already we've seen results from that. The employee supervisor and/or risk management will conduct a rapid assessment of any vehicle, powered equipment accident, or injury accident, preferably on scene or otherwise by phone, and if possible, including discussion with law enforcement officers on scene when such officers have responded. A decision on whether to send an employee for post-accident testing will be made by the department head or designee upon recommendation of the employee supervisor and/or risk management based upon the initial assessment. Employees with commercial driver's licenses who are involved in accidents are subject to the testing procedures required in the Code of Federal Regulations, Title 49, blah, blah, blah. I'm not going to read all that. Personnel Policies and Procedures Section 5.42A4 states the following: consistent with business necessity and job-related purposes, all employees shall submit to alcohol and drug testing if any of the following circumstances apply: investigation of possible individual employee impairment, investigation of accidents in the workplace, including but not limited to vehicle accidents when the employee is driving a state, county, or personal vehicle within the scope of their employment. Employees may be required to undergo drug testing or alcohol impairment testing for accidents if the test is taken as soon as practicable after an accident and the test is administered to employees who the employer reasonably believes may have contributed to the accident. Maintenance of safety for employees, customers, clients, or the public at large. This includes but is not limited to the following situations where employees were involved: loss of life or serious injury, issuance of a traffic citation to the employee for a moving violation arising from an accident, and reportable damage to county or state property. Maintenance of productivity, quality of products or services, or security of property or information. Reasonable suspicion that an employee may be affected by the use of drugs or alcohol and that the use may adversely affect the job performance or the work environment. For CDL drivers, as soon as practical following an occurrence involving a commercial motor vehicle operating on a public road in commerce, the county will test each surviving driver for alcohol or controlled substances, and this is strictly out of the CDL guidelines. So they're federal guidelines. Who was performing safety-sensitive functions with respect to the vehicle if the accident involved the loss of human life, or who receives a citation within 8 hours for alcohol testing or 32 hours for controlled substance testing of the occurrence under state or local law for a moving traffic violation arising from the accident. If the accident involved A, bodily injury to any person who as a result of the injury immediately receives medical treatment away from the scene of the accident, or B, one or more motor vehicles incurring disabling damage as a result of the accident, requiring the motor vehicle to be transported away from the scene. So that's a lot of stuff I went through on that, and it's all in the Personnel Policies and Procedures Manual. But the takeaway from this is if an employee is involved in any accident, any workplace accident, whether driving a vehicle or it's an accident doing something else as part of the job, and it looks like that person contributed to that accident, then they're going to be taken for testing. So, discrimination and harassment. Significant losses can occur due to lawsuits resulting from discrimination and harassment claims. These could also result in loss of good employees and negative impacts to the county's public image. Supervisors should be fully aware of their responsibility to understand what constitutes discrimination and harassment. Remain alert to indications of such behavior and immediately take action upon being aware of such behavior. It should be understood that such behavior can be intentional, but can also be the result of unthinking or misguided comments. All such behavior can result in claims and lawsuits and cannot be tolerated. Arizona County Insurance Pool provides a harassment in the workplace training every few years. A video of the last training is available on the county employees webpage. So we do encourage our supervisors to take that harassment in the workplace training. And that may be something that we may want to put in a policy, making it potentially mandatory. So we are looking at that now. And I think it's something that is a matter, I mean, in our workplace, there's always a lot of joking around and with your coworkers and making fun of this and that. But I think most of us know what's allowable and what isn't. But I think sometimes supervisors may be a little bit too lenient on some things, and need to stop and think and say, well, maybe there's something here I need to put a break to before it gets out of control. And you never know when somebody may take something the wrong way and it results in a lawsuit against the county. So there again, that comes back to the supervisor's role, just as the supervisor's role in maintaining a safe work environment and being sure their employees are adhering to that. And that plays into being a performance issue, so that employees that, employees that are not being as safe as they should, or maybe doing things they shouldn't be doing at the workplace that might potentially be interpreted as harassment or discrimination, then that's a matter that needs to be dealt with immediately by supervisors. And probably, if it's bad enough, I'd say certainly if it's bad enough, it needs to be documented in that person's performance evaluation, and possibly in other documentation as well. And it plays into whether that person may, gets rated high in their job or not. Doesn't matter how good a job they do otherwise. If they're doing things that could potentially put the county at risk, either from a lawsuit or whatever, then that's something that can't be tolerated. So on ADA compliance, I wanted to touch upon this a little bit because we've had questions on it by multiple departments. If a facility visitor asks for a mobility accommodation such as a wheelchair, RIS should be notified. Now I'm going to qualify this a little bit because there's people that have a different opinion on this, and I'm telling you what my opinion is as the risk manager, which is the opinion of the county, as long as I'm risk manager. But employees, and this isn't just my opinion, this is an opinion where I've researched with Insurance Pool and with legal, but employees should not ask a visitor if they need a wheelchair or other accommodation. While this is customer friendly and certainly shows compassion and willingness to help, it also opens up potential liability issues that could result in litigation. So if you have a person that's coming in that's having difficulty getting around, yeah, you open the door for them, whatever, but don't ask them if they need a wheelchair or any other accommodation. Because the moment we start trying to help somebody, the moment you put somebody in a wheelchair and start to wheel them around, or even if possible, you grab them by the arm and try to help them around, and they fall down, and even though you haven't done anything, what's the potential there? The potential is they fall down and they're hurt, that they're going to sue the county, even though you were trying to help them. And while it may go against our grain, not to be helping people like this, I mean, if they came into the building without a wheelchair or without a walker or whatever, then they came on the basis that they can come into the building and take care of their business. So it's not up to us to try to change that and say, hey, can we get you a wheelchair? If a visitor alleges that the county is not providing adequate ADA accommodation, the visitor can be referred to the clerk of the board to file a complaint. But as we all know, a lot of our business doesn't have to be conducted in person. Part of ADA compliance means we've provided means for that person to combine to actually take care of their business either by phone or by email or whatever. So we have to remember that that's all part of this. Now, do we have to have ADA compliant parking spaces and doors and that type of thing? Yes, we do. And if any employee looks at something and says, I don't think this door is working right, or I think we need to do something different here, then that needs to be called to the attention of a supervisor and call the attention of risk, and we'll look at it to see if something needs to be done to be sure we are actually in compliance with the ADA regulations. But I have to say that our facilities department is very good about that, about being sure we're ADA compliant in our facilities. And risk management, one of the reasons that we do annual inspections on buildings is to go through and be sure that we're not missing anything, not just ADA compliance, of course, other things, safety issues, but that's one of the things we look at as well. So if you're talking about, if we're moving on and talking about service animals are only dogs or miniature horses. They're allowed in county facilities, just like they are throughout the country. But they're the only things that are allowed, dogs or miniature horses. Employees can only ask a person who comes in with an animal whether the animal is a service animal and what service the animal is trained to provide. Those are the only two questions that you can ask, legally ask. Employees cannot ask for any documentation on the animal and must accept adequate answers. And this is a common misconception and why we try to train all of our employees who deal a lot with the public, that they have to understand that a service animal, there's no such thing as a certification for a service animal. No such thing nationwide. And which is good in some ways, but in other ways it allows for people to say, you know, their animal is a service animal when it's not. Just because the animal's wearing a little coat that says service animal on it doesn't mean it's a service animal. I've been shown things from certain people that says, a little thing they have in their pocket that says, officially this is a service animal. They have a certification from some bogus organization that sells this stuff online to somebody for $25 or whatever, and say, okay, now your animal's certified and you can show it to somebody. Meaningless. Legally, we can't even ask for any kind of documentation, and there's no documentation that can prove it's a certified, it's a certified service animal. So we ask those two questions. If they answer those two questions adequately, then we allow them to come in as a service animal. If the owner says the animal provides comfort services or shows a certification that it is a service animal, like I say, no such thing exists, then the person should be asked to leave. And if the animal misbehaves or runs around without a leash and is unresponsive to commands, then the owner should be asked to leave even if the two questions were adequately answered. It's not a service animal if it behaves. If it misbehaves, I should say. It's not a service animal if it misbehaves. Service animals are trained to be very good about behaving. And in certain types of disabilities, it's not necessary for even a service animal to be on a leash. Most of the time it is, but if that service animal can be controlled by voice, by the person who's handling that animal, then that's acceptable as long as it can be controlled by voice and it's not misbehaving. So, and I should say, and what I have written down here is a little misleading, because the owner should actually be asked to take the service animal outside. The owner doesn't have to leave, but if the animal is misbehaving, he or she needs to take that service animal outside, and then the person, the owner or whoever's handling that animal, can come back in. They can come back in, but they just can't bring the dog back in because it's misbehaving. So I just wanted to clarify that a little bit. For medical incidents, and I talked about this earlier, and I'm just going to run through it briefly again as a reminder, but any employee who is sick or unable to safely perform duties due to physical conditions should be sent home until recovered. Any persistent medical issue that appears to affect an employee's ability to safely perform duties should be brought to risk and HR's attention. If a visitor or an employee has a serious medical issue, 911 should be called even if the victim does not want it called. Ambulance transport can be refused at the scene. Anyone who suffers a severe fall must not be moved, and 911 should be called. And a lot of you are familiar with why that is, because if a person suffers a severe fall, they might have a head or a spine injury, and you don't want them moved. You want to have the EMTs come and evaluate that person, and if they have to be moved, then the EMTs will do that. So we need to be very careful about that. And obviously it's our first reaction if somebody falls is to go over and say, hey, are you okay? And here, let me help you up. And in some cases that's okay if it's not a severe fall. If that person hasn't fallen hard on their head or hurt their neck or their back. But in other cases, you just need to leave them where they are. Ask them how they're doing while they're laying there. If it looks like there's that type of severe injury, then try to make them as comfortable as possible while you call 911 and get the EMTs to come and evaluate them. And I already covered this, that if a visitor or an employee refuses transport as recommended by EMS, they cannot then be transported to a medical facility using a county vehicle or by on-duty employees. And if off-duty employees decide to do that, they will be accepting personal liability. Employees who use CPR, stop the bleed, or AEDs are protected by the Good Samaritan law, but employees trained in these techniques should be called to assist. So one of the things we talked about in our flip chart training that I did a couple weeks ago was that on your flip chart, you can write in those employees who you work with in close proximity who have been trained in CPR, stop the bleed, or AED, or first aid, and be able to call on them to help in a situation while you're waiting for the first responders to arrive. So it's a good idea to understand who those in your immediate vicinity are who are trained. To be sure you know where the AEDs are and that type of thing. As I mentioned in the flip chart training, we are going to bring in more stop the bleed training opportunities for people, as well as training in CPR, first aid, and AED. We are going to provide stop the bleed kits, or essentially the tourniquets and those type of things that you need for stop the bleed. We're going to be providing those at each AED station, and also we'll be having at least one separate kit that will be available to each department or division aside from what's at the AED stations. We are going to be moving a few of the AED stations that are now behind locked doors in individual departments, because our evaluation, recent assessment on that is they have to be out where they're accessible to the public and to where you can get to them, I think, within 3 minutes or so of the need. And so when this building was set up, there were several AEDs that were put behind locked doors where it would require the person an employee of that particular department or division to actually let somebody in to get to that AED. And that may not happen. That person may not be available to let anybody in. So we are looking at moving those. Public access. Citizens can take photos or videos in any area accessible to the public in county facilities. And this is another question that we've had come up repeatedly. They cannot be prohibited from doing this. If doing this in areas where there are children present, they must be accompanied by a staff member. They can't be just wandering around on their own. But they can't be prohibitive. If it's a public area that's accessible to the public, it's fine for them to be recording that with their cell phone or whatever else. And this is sort of a repeat of what I put earlier, so I'm not going to go over it again. I pretty much covered it in my earlier discussion about service animals and how they need to be under control at all times. So that's the end of the slideshow. It only took an hour. I'd planned on an hour and a half in case it took me longer to get through it, but I ran through it pretty quickly. And that's what I pretty much wanted to present. Does anybody have any questions on anything that I didn't cover? Okay. For safety sensitive positions, Well, it's 0% anyway for any controlled substance, unless you've got a medical marijuana card. But that's a good question. The question was, for those of you that are online, was if it was safety sensitive positions, if it was zero tolerance for controlled substance, and it is anyway for marijuana. But in terms of alcohol, I mean, I'm going to have to look that up because I don't remember right offhand whether it is or not. Well, the question was, if somebody was on the job and I guess was injured on the job or had a medical event on the job, and they didn't want to be transported by ambulance, but they requested a coworker to take them to the hospital, and whether they could take PTO time to do that. Essentially, yes. I mean, if they, whether it's PTO time or whether it's comp time or whatever, I would suppose they could do that. They might want to check with their supervisor first before they do that. And that would be up to them if that's the way they wanted to use their time and they had approval for their supervisor, and they could do that, taking them in a private vehicle of whatever means. So you could do that. But I would advise that employee of what I said in this presentation, that understand that you are assuming personal liability at that point for that individual you're transporting. And in some cases, you may make the friend of that employee, the coworker, may decide to take that risk, assume that responsibility. And it's understandable because we all want to help our friends as much as possible. But I would caution them on the basis that if that person that was injured or had a medical event can call a family member to come and get them, that's probably the better way of going about it. But it also depends on the degree of the injury. And sometimes you may not know that. If you've called 911 for an ambulance, then you've made that 911 call for a reason, because you felt like that person was potentially had a serious injury or having a serious illness or whatever. So I think the way I would look at it would be if I felt like that person had such a serious injury or illness that it might affect them while I'm driving them to the hospital, I think I would hesitate. I might still make the decision. I want to help this person, but if I knew that situation was bad enough that something might happen on the way to the hospital, and to that person before I could get there, I think I'd be real hesitant about that. And but I think the key thing is the person needs to understand that they are opening themselves up, and they're being a good Samaritan trying to help their friend, but they are potentially opening themselves up for personal liability. And nowadays, when you look at the litigation environment out there, we would say, well, I've known Joe for 10 years, and even if he died on the way to the hospital in my car, I'm trying to help him, and he's a good guy. He would never want me to assume responsibility or be sued for that. But what about Joe's wife or Joe's parents? And they said, well, Bill took Joe to the hospital, but he didn't get him there in time. Or maybe he had a flat tire on the way or whatever, and so Joe passed away. It was a heart attack. You didn't get him there in time, so I'm going to sue Bill. And it's unfortunate that we're in that particular state in this country nowadays that we have to, every time we turn around, we have to consider those type of things. But and so we don't want to get to the point where we're not doing the right thing to help people, but at the same time, we have to look at it and say, number one, is that the right thing anyway? One reason why we would encourage people, I would encourage people, if the EMT says we need to transport you, I would encourage them to do that instead of, saying, oh, I'm going to ask somebody else to take me, because that person may need that EMT's medical attention on the way to the hospital. So it's for that person's protection and safety as much as anybody's. But the other thing you have to consider is the personal liability that you might be assuming that may, the liability that may come back on you. And that's why I talked a little bit earlier about the injuries on the job. A supervisor or coworker, if they're not following the proper procedure and they put that other worker at risk and they get injured, as I read, according to Arizona law, that supervisor, that employee that may have contributed or caused that particular accident to that other employee can be individually sued. And because they violated county policy and procedure, the county's not going to protect them either, because they violated their trust with the county by not following the proper safety steps. So it sounds harsh. But one of the reasons I wanted to do this presentation was to put this stuff out there for people to be thinking about. And something we need to be aware of as we go through our daily jobs, and particularly in some jobs more than others, because obviously our office jobs here are not that hazardous other than trips and falls and that type of thing. But some of our other departments across the county have really some serious risks they have to incur. And it's just something we all need to be aware of. So, and I think, if I remember correctly, I think our overall email address that we set up for workers' comp type of injuries and for sending SRIs to, when you want to send them to risk instead of sending us a fax, I think that just says workerscomp@mojave.gov. So I think that's what you should use instead of the fax number I put on here, and I'm just going to have to update my slideshow in case anybody wants to use it after I leave, which they may not anyway. But anyway, that's the most recent thing. So I wanted to cover these things primarily to call attention to the things here on loss prevention that we all need to be aware of, and to understand that there's things we can do and things we need to be aware of, both to protect our employees and the county from certain things. And in particular, a lot of things I've covered here is after that person is injured, after something's happened, what do we need to do to be sure that everything's taken care of as it should be, as that we go through the process, the workers' comp process, or whatever is involved after the fact, whether it's post-accident drug testing, alcohol testing, whatever. There are certain procedures we have to follow. We did change our procedure a little bit a few months ago, where risk management is more closely involved on all workers' comp cases, because in the past a lot of it went directly, once that person went to a medical facility and workers' comp went to, the incident report went to Arizona County Insurance Pool. Well, then Arizona County Insurance Pool employees would be the one working directly with the injured employee. But we found out that there was gaps there where the employee wasn't not necessarily telling the supervisor what was going on. In some cases, we were getting information from ASIP on what was going on. Other cases, we weren't. And so we decided from this point on There's going to be somebody from risk management that's going to be involved right up front when an accident happens, and we're going to be trying to track that throughout to be sure nothing slips through the cracks, to be sure that we do get the appropriate return to work information, that we do get the appropriate light duty requirements given back to us, to be certain that that person doesn't come back to work when he's not supposed to. Be sure that the bills are going to ASIP and not going to the employee. Just better track this to be sure we're keeping up with what's going on. One thing I didn't mention that I intended to mention and I intended to put in the slideshow was another thing that we found out, that some of our departments and divisions were in fact keeping a lot of individual employee medical information from the injuries that they shouldn't have been keeping, because all of those should be coming to risk and HR for us to keep. And primarily what should be kept at the individual departments and individual divisions would be possibly a copy of the return to work and a copy of the light duty. But most everything else needs to be sent to risk and to HR, and we keep it in a confidential file where only certain people in our departments have access to it. And it's not something that should be retained in an individual department, and particularly if it's in a situation where multiple employees could accidentally see this information. So that was one thing I intended to mention and I failed to, but I wanted to bring that up before we wrap up here. So that's all I had to offer at this point. So any more questions? If not, I thank everybody that was here in the boardroom and everybody that was online participating in this. And like I said, this is going to be on the employee webpage for people to look at in future. And please be sure and contact me if you have any additional questions that I wasn't able to answer in this presentation today. So thanks again, and I do appreciate the job that everybody does out there. All of our supervisors, all of our employees do overall a very good job on staying safe. But we're doing everything we can to be sure and keep the number of incidents down, to keep our employees safe, and to hopefully reduce them and eliminate some things that could hurt some people and that could potentially hurt the county financially as well. So appreciate the job everybody's been doing, and I encourage you to keep up the good work. So thank you.